Okay, welcome back, everyone. So we will begin panel 2, and I'm going to turn it over to Margaret to begin our discussion about the feminist legal process in intersectional justice.
Thank you, everyone. Good afternoon. I hope we all had a good lunch. Yeah, so I personally had a good lunch. So I'm Margaret Ajok. I'm currently a student at Columbia, and I have worked in Uganda for over 10 years, basically doing policy work with the government of Uganda. So I've taken a break and now I'm a student and now I'm moderating this panel. So there's a little bit, there's a slight change in this panel. We don't have Teddy Atim, who had some problems with her visa getting approved on time. So we basically have 4 panelists right now, and starting from my left, there is Lorraine Smith, who is the Executive Director of Tawala Justice for Women. We have Angela Lacour, who is a co-founder of Watie Kigen. Fortunately, I speak the Acholi language, so Watie Kigen means we have hope. Then we have Angela also Mudukuti, who is an international lawyer, and right on my left is Alexandra Lilly, who is also the co-founder of Emergent Justice Collective. So this panel will basically be reflecting on the legal process, some of the challenges and structural barriers to international justice. What are some of the issues that what are some of the barriers to effective participation? How do we address those barriers? So I will start off with Lorraine to get us speaking about what it means for inclusion of victims, why it's important to ensure that victims' voices are reflected in national and international justice processes, looking at some of the policy issues that affect them, how can we move away from that, and also look at some of the findings that Tawala had from a survey that was done for women leaders, basically to highlight some of the structural barriers that they have. So Lorraine, I'll give the floor to you.
Thank you very much, Margaret. Is the microphone on? You can hear me well? Okay. Thank you very much. It is such a pleasure to be here. As Margaret said, I am Lorraine Smith Van Lane, and I started Talawa Justice for Women because I'd been working in the international justice space for a few years. I refuse to tell my age, so don't even try to get me to do it. And I was concerned because of work that I'd been doing with the International Criminal Court and with many of my colleagues in this space, that we were not as close as we needed to be with those on the ground who were really affected by the decisions that were made by the International Criminal Court. I actually went to Uganda, and I think Uganda adopted me a little bit, and mainly because of the work and influence and life. I'm trying not to become emotional, of somebody who meant a lot to me and became a mentor, and that is the late Lady Justice Elizabeth Nahamia, one of the stalwarts of justice in her country, who unfortunately passed away late last year. And so I'd also like to dedicate this event to her as well and to her memory. So Talawa was started because I wanted to ensure that there was a platform for women who are activists on the ground in their countries where they have been impacted by gross human rights violations, and that they would be part of discussions, that they would find a place at tables where decisions were being made that affected them. And that led me to Gulu in northern Uganda, quite a trip from Kampala, and quite an interesting trip and quite an interesting experience. But it led me to persons like Pamela Angwesh, to Victoria Nyanjura, to Angela, to Sylvia Achan, and so many other women who are working diligently to try to ensure justice in a context where they've waited for over 20 years. One thing when you are proceeding in an international justice process and decisions are taking a while, But when this is your lived experience and you're waiting for 30 years and your child born of war is now a man, it has different connotations. So it's against that backdrop that I'd like to talk a little bit today about victim participation and what that means and how we ensure that the voices of survivors, and I say very quickly because of something that Victoria said today, of survivor activists are included in the discourse on feminist perspectives on international justice, that they are included in some of the key decisions that are being made at the ICC. I want to firstly say that in the Ongwen case in particular, but at the ICC in general, we most of us who follow the ICC know that the ICC has a fairly robust and very innovative victim participation regime. It is innovative because it certainly is quite a departure from the situation at the ad hoc tribunals where victims were not allowed to be participants in their own right. They were able to participate as witnesses for the prosecution. The Rome Statute is innovative because it not only allows victims the right to reparations, but to participate if their interests are impacted in some ways by the proceedings. And so they're allowed to present their views and concerns in a way that the judges of the court may deem appropriate. And of course, if it does not impact or impinge on the rights of the defense. And it's excellent. It's a very progressive piece of legislation, the Rome Statute, and it is not limited, of course, to Article 68. We know that there are other provisions that give victims very specific rights to participate. And we've seen that in other subsequent mechanisms as well. And I think it is important for us to recall that that exists. So the framework exists. But those of us who have been following the court long enough will admit also that it hasn't quite worked out the way we expected that it would have. And it could be because there are teething pains with trying to understand how to interpret this novel piece of legislation, this novel provision, to ensure that the voices of those most affected are included in these processes. So we've seen that the ICC has had teething pains. How do you actualize victim participation when you have a court that is based in The Hague and those affected are based outside of The Hague, some of them quite remotely so? And we also think about the implications of having a court that is limited in terms of resources. So the judges may wish to include many voices, but then states parties who determine the court's budget will then say, well, this needs to be capped. In fact, they use the term, it's a cost driver, which means that it has potential implications for the court's budget year in and year out. So how do we bridge that gap? How do we ensure that what may seem to be a wonderful normative framework for participation of victims translates to actual meaningful and effective participation? And this was a challenge that the independent expert review of the ICC also picked up on. The independent experts noted that the system, even the procedure, the process of participation is bureaucratic, it's complicated. It doesn't seem to mean very much for victims. That said, we understand that it is not that we're expecting 5,000 victims to show up at the ICC's door. This is done through legal representation. But even that has been challenging. And we saw that even in the Ongwen case as well. You had Ugandan victims wanting, of course, to choose their own counsel. But then the judges at the pre-trial phase were reluctant to consider the grant of legal aid, because if the court appointed a common legal representative, then it would, of course, imply that there may be legal aid considerations. So there were tensions at the beginning, and I would recommend very strongly a Human Rights Watch report on that issue. So what we've seen is tensions in terms of actualizing what is a wonderful normative framework, but one that is nevertheless absolutely critical. It is critical that victims participate. It is critical because it gives legitimacy to the ICC's processes. It gives legitimacy not only to the ICC's processes, and I want to be very clear here. This is not just about participation in ICC processes. This is about ensuring that victims' voices are heard in other processes, transitional justice processes. How do we ensure that transitional justice processes do not exclude victims? How do we ensure that they are part of the decision-making process? So I'm going to just mention one or two things that I think, and then hopefully it will contribute to a broader discussion. And that is what are the three key things? The first is because victim participation is a procedural right that must be enforced. And it is key to the realization of some of the broader substantive rights that victims have in criminal justice proceedings. The second is something that I think is very meaningful, especially in this context, and that is allowing victims to participate challenges the idea of them as passive or weak, focusing instead on their power as change makers, as experts, as Victoria put it, with firsthand experience, knowledge, and expertise, which contribute significantly to the justice and accountability process. And thirdly, because victims bring crucial contextual and situational knowledge to the proceedings, particularly where, as I mentioned before, the accountability mechanism is located far away. So as we continue this discussion, I will share perhaps later a little bit about how we've managed to, or we've been trying to do that with Talawa. And it would be very interesting to hear also from my colleagues, and particularly Angela, about their experience of victim participation or engagement in these contexts. Thank you very much.
Thank you so much, Lorraine. It's so interesting that you talked about the fact that you looked at this idea as a platform to give victims, especially from Uganda, the opportunity to speak about some of these things, and just got me thinking about the whole context of Ukraine right now. There's so much international attention to Ukraine, and yet we have also situations which have been existing, but there seemingly isn't that much attention to it. So I think this was really a brilliant idea, that we need to keep the conversation of victims on the radar. It doesn't matter when it happened, but the fact that victims are there, they need support. I think it's something that really, really is commendable. Then also one of the things that I think I took out that was really so interesting was looking at procedural rights. In my own reflections, I was thinking about procedural rights being something good, but also at the same time also could be a barrier to victim participation. So, and also following up from the panel that we had in the morning about so much progress at the international level, and then very limited progress at the national level. So looking also at my experience with the International Crimes Division, we try to open up the issue of victim participation, but it's kind of playing out as a double-edged sword, having victims participate, but at the same time, we do not have proper processes for protection of victims. So you could look at procedural due process rights as a right, but at the same time, they could actually be limiting or actually endangering some of the victims. So that's something that I really took out. So I think we'll then move to Angela Lacour, who will briefly, who will also share reflections with us on some of the barriers for survivors to participate. Thank you.
Thank you so much. I am really humbled to be here, and I would like to appreciate the organizer of this event and everyone, all the partners that have taken their time to listen to us. Actually, my name is Atim Angela Lacour. I am a survivor of sexual violence. I am a co-founder of Watiek Again. Watiek Again means we have hope. It is a community-based organization in Northern region. And Watiek Again started in 2013. And this year in October, we'll be making 10 years in the field of implementation of struggling for our hope, for our freedom. And I really appreciate that so much. Yeah, Uh, uh, One of the things that I've been experiencing during all these years, I'm going to talk particularly of the things that we have met along our advocacy, along our implementation in the community, and also with other actors. One of the things is that like our colleagues mentioned in the morning, one of the things, the barrier is ignoring and denying that the atrocity or the war happened. Because up to now, there's still delay in acting, in help, in supporting the victims. There's delay in redress. We are seeking for redress, but we are not having that. So I think that is one of the things, one of the biggest barriers that we are seeing. And then illiteracy. Most of the survivors are not learned, they're not educated, and people take advantage on that. Like Lorraine just mentioned about the ICC. We thought, because we were asking ourselves among the survivor-led organization, were you part of this? Did you have you been informed on this? And for sure, we were not part of it. We were not part of it. But at some point, I was connected, and they were sending me a lot of emails with notes to read, and too much. I appreciate that, but it is really so difficult for us to understand the legal part of it, how to explain it. We need someone to come and explain to us. We need that connection. And those are some of the barriers that we are experiencing in our implementation. When it comes to law, there are certain things that we interpret differently. And with the law, it is interpreted differently. But we want to be part of it. We want people who can listen to us and understand the exact point of what we went through. I still appreciate the second team that presented. They were coming up with a lot of things that happened. And I was like, okay, I think even if we were not there, we whispered with Victoria. These people also learned something about it. But what I'm bringing here is, every survivor is unique in their own way, and every voice, what they had gone through, it matters. It is, at least if you talk to 10 survivors, you're going to learn 20 new things from the 10 people that you've contacted. So the reason why I am bringing this, yes, they brought it up well, and we appreciate that. But when they were talking about the sexual crime, I thought of, how do we put this, that like maybe the survivors that have been used, like one man spreading like 10, telling 10 women to sleep next to him, and he's using one by one while others are seeing. Have you got that? Have you heard of that? Those are some of the things that if you speak to survivors, you'll understand there are certain things that happen that are still not out there. And if we don't connect the barriers of communication, putting survivors first, we'll miss it out. You will miss some of the important things that we are supposed to understand, that the world should see. It is not about Uganda. It is about the children, that the future. It will help us also for the reference. And one of the things that also I was thinking of, do you know that these people wanted to know when you're having your period? And if you don't, you try to change the date, the date that you're having your period, you're punished. And you're prevented from reaching some place because they say, okay, you're not holy. I am not holy, but you want to know my period, so that at times you also use me during that particular time. So some of these things, it's the reason why we say the survivors, put the survivors at the center, whereby if you're turning this side, you have this unique information from a particular person that is saying, you know what, I fear to mention this, but this is what I went through. Us personally, when we came back, I didn't know that there were people who have been used even when we were moving, because the way we were taken in groups. I think those are some of the things that actually, I'm sorry to go there, but I just want to emphasize that let the survivors speak on what they have gone through. And then one of the things that some of the barriers that I also feel that it is there between us and the people who are working. Like, for example, the ICC, to be sincere, I appreciate what they have done. I am so happy, because at first I was thinking, how will it work? You know, the Hague and Uganda, and then North, East, these people, how will it work? You know, at least they tried. It is at least they tried. Although we say it has taken long, but when there was that appeal, I was like, okay, you see now where things go to. So let's just pray and put our knees down. And then we pray to God. I personally, I pray a lot. I'm a believer. I pray a lot. And because to me, I say, this is a first step, you know, this is a learning point. We cannot be criticizing that we have not done much. Yes, we have not done much, just for future reference, so that we do more. But we have gone a step forward. We have worked hard to do this, because the perpetrator, when Ongwen was sentenced, when Ongwen was taken, we were thinking, some of the survivors were thinking, how about these ones who are moving? For me, this puppet what did a lot of atrocity on me. Why is he still moving here? Why can't they go and take it? And there were some of the questions that when ICTJ brought in meetings and the survivors were asking questions. Are you going to do the reparation also in the Hague? You know, how the connection, that barrier. I'm sorry to emphasize this, but it means a lot, but also we appreciate that it has come to pass. Now it is the time that we want to see that survivors are put first. Survivors are taken in this reparation, so that we know that, okay, these are the people who have got this, and then these are the people who are still left. And then we are asking, how did the ICC connect this with the Ongwen? Did they say, okay, Ongwen, those are for the Ugandans, and then for the Ongwen for the ICC, and then for Koyela, you Ugandans, please continue with the Koyela, because up to now we have not we don't know much about the Koyela. Was there any communication among that? Because if you are to see the survivors, if you are to ask from the survivors' perspective, they would say, okay, I think for now, I would say I understand the one for when, because of, you know, they were hearing, broadcasting it, they were doing this. At least there were a team who are going there and talking in public. At least they gave us this screen that we are seeing. How about the one for Koyelo? You know? Where was the connectivity among that? Those are some of the challenges that we meet, because when we are, right now we are talking about reparation, and then we say, okay, how about doing it at, you know, doing it together, so that, because there are some of these survivors who are saying, I am having this bullet on me, but I am not among these people, you know, but I could be among the one for, core yellow. How is it going to connect? Is the reparation going to be something that is going to bring harm to the survivors, or is it going to bring repair? Or I don't know. I'm just thinking on behalf of the survivors and as a survivor. So I think that is some of the challenges that we are experiencing. And then the lack of political will. You know, it still goes to denial, no interest. It's like the survivors are already okay. No one can pick that interest. We have the parliament. If it is time for election, everyone wants to, because they know, okay, this war has taken almost north, east, and, north, eastern part of Uganda. So at least every household has the victims. And they promise everything. They promise lots of things for the victims because of that time only. And at the end, no one is taking for example, the petition that was taken in the parliament. No one is coming up to emphasize on that. But they are promising things, but at the same time, they're saying you are okay. You are okay, you know. So I think that is some of the things that we are also experiencing as one of the gaps. We have lack of trust and accountability, and this. I think people see it is like they are not learned, they don't know much. I would like to bring about Watiekigen. Watiekigen is a name that was nominated, and we respect it. It was not a personal a name that I came up with or my colleague came up with, but it was 85 women that decided that leave the organization to be called Watiekigen. Because we are not educated, we feel it. If we say Watiekigen, we have that hope that our voice matters. We have that hope that we'll speak for our children. If people are not going to hear us, we'll continue speaking. We have that hope that we are going to push it. We are going to push for our freedom without backing up. This is us, and this is Watiekigen. So saying that, okay, this is a local, first it is a local name. Why do you have to bring them? Why do they have to talk? They don't know anything. But respect and the trust that the survivors, it is like every human being needs that respect. Every human being needs that trust. So that lack of trust and the lack of trust and accountability to survivors, like we have lots of scholars. Always I ask questions. If you're bringing scholars, yes, which is very good. You've done your research. Please give a feedback to the survivors. They feel honored, you know. If you're writing something, if you've spoken, you've interviewed a survivor, please give a feedback. We are doing the trial of Ongwen. Please go back. This is the stage where we are in. But for Core Yellow, every time there's no money, there's no this. Even the ICC are crying, there's no money. There's no money. But how far can we go about saying there's no money, but we can reach? So it is all about me to do my part, and then the rest follows, you know. And then this also, the donors feel like, okay, I don't think they can manage this. And then there are some excuse me, there are some restriction on application, whereby they say, if you have not received maybe $200,000 US, we cannot give you. And or if you don't receive, maybe you have maybe this amount of money, you're not eligible to apply. So you're shutting down all the survivors group not to apply for a particular thing. And they are survivors, they are in the community, they are seeing this, they are experiencing this problem, and they look to the bigger organizations, you know, and at the end, the problem continue. So if we can build that trust, and let's try them, let's try the survivors organization, and we see. And then, yeah, I think lack of redress. Yes, I have mentioned that. You know, we have really tried. People are really we really want someone to come up. We want the government, our government, to come and stand for us. We want to get that redress. So those are certain things that really stops us from moving forward, and it keeps like haunting us. And that is why there are times that the survivors, when you come like to do interview, and they say, we are tired, because you do it, we go, and we don't have feedback. I think, yeah, that is. Thank you.
Thank you so much, Angela, for the courage to speak honestly about these issues. There's a lot of context that Angela has put forward that I might have to step in, because fortunately I have context to that. And I will do that very briefly. I think some of the issues that she spoke to, I think that I really think are key are the harmony of the national and the international prosecution. The core yellow case is basically a national case that is being prosecuted by the International Crimes Division in Uganda. It's also a case with respect to the Lord's Resistance Army. So he was also senior level commander who is being prosecuted. And from what I hear her say is, what's the harmony in between the reparations that have been awarded in the Ongwen case vis-a-vis the victims already that are also there with the core yellow case. So victims are probably asking, I think it's something that they've asked, that there are reparations in Ongwen and there is nothing yet in the core yellow case. So that, what does that mean for us? I think that's something that's really key. The other issue that I think that she's also mentioned is about, though she didn't say it, I think it's about some perceived perpetrators who are in the community, and the victims feel that they should have been prosecuted, but they are not in any of the national or international prosecution mechanisms. So that's something else that also I think the communities are questioning. So where do those ones fall? Where is the justice for them, and if they are already in the community? I think the other issue also that she has spoken to that I think is really important is the issue of the fact that victims feel that their efforts are unyielding. They are trying as much in their own capacity with the limitations that they have, but their efforts are not yielding. She's talked about the petitions. There was a petition that they made to the parliament for reparations, and there is really nothing tangible that has been done with respect to that. So I think it also puts a lot of question in terms of how much do victims have to do, and how long do they have to wait at a time where their efforts are actually unyielding. So I think those were some of the key points that I thought I needed to put in context for you. So I think I'll move quickly to Angela Mudukuti to basically give us insights into her experience as an international justice lawyer. Thank you.
Thank you very much, Margaret. And what a pleasure and an honor to share this platform with all of you, especially our Ugandan colleagues. Thank you so much. So I'm going to zoom out a little bit and talk about some of the structural barriers in international human rights and international criminal law. I'm not racist. I have Black friends. I didn't mean it like that. I do not see color. You're being too sensitive. These are some of the common responses you get when people are confronted with their racist behavior. Racism and discrimination, these are structural barriers to effective and meaningful participation, particularly in international criminal law and in human rights. But let me take it back to where it all begins. Imagine for a moment you are from the global south. You are a person of color. You are outraged by human rights violations and you decide you want to fight the injustice. You want to work in the human rights space. You dream big, ICC, UN. But you can't get an internship because they're mostly unpaid. And you can't afford to live in Geneva, The Hague, or New York without a stipend. But that's where you need to be to get your career going. It's no surprise that today, 49.2% of the UN interns come from Western countries. And you see this pattern replicate itself in UN leadership as well. Those who take unpaid internships often have generational wealth, access to funds that makes an unpaid internship a welcome opportunity. But somehow you get something and you end up bouncing around from one short-term contract to the next. But it's hard to get a visa. And sometimes you can't apply for certain jobs, certain consultancies, because they don't sponsor visas, leaving all the opportunities for those who come from the EU or the US or other global north countries, the more desirable nationalities. Then you find out that as a matter of policy, official policy, the number of staff positions at the UN or the ICC are proportional to a state's financial contribution. And that favors people who are predominantly from states that contribute significantly, particularly the global north. As we speak right now at the ICC, there are 473 professional staff and 256 of them come from the group that's known as Western Europe and other states, the WEOG group, essentially the global north. That's more than half of the ICC staff that come from 1 out of 5 global regions. So you think to yourself, okay, what about positions in the field office in the global south? There you'll find that they're mostly filled with people who are from the global north who are seconded or funded by their own governments and also earn more than the local staff. So that's the situation at international organizations. What about civil society? In particular, what about international non-governmental organizations? Same visa struggle there, not to mention difficult dynamics between the INGOs, international non-governmental organizations, and their local partners. INGOs tend to look down on their local partners and come in with a top-down approach that often is condescending and laced with the belief that local actors don't know how to help themselves. So whether you work at the international INGO, the international organizations, or the INGOs, you yourself may face systemic racial discrimination. Your supervisors will try to set you up to fail. Your subordinates will try and undermine you. Sometimes it's subtle, sometimes it's blatant, sometimes you report it, sometimes you don't because nothing will be done. It's almost like it'll be swept under the rug. The perpetrator will likely be promoted and you will be deemed a human resources liability. At best, the perpetrator will be sent for sensitivity training as if being sensitive is the same as being racist. There'll be attempts to silence you, threats and accusations will be made against you. Many of people of color in this field will identify with this story. I've heard these accounts from my friends and colleagues, people I hold dear. And it is with their permission that I tell their story, our story, the story of people of color in this field. What's worse about this environment is that it's people who you expect to know better who perpetuate discrimination. Those who can recite from memory laws that are designed to promote and protect equality and the right to be free from discrimination. Those very same people who become very defensive when you confront them with this. And you will hear, I'm not racist, I have Black friends. By the way, this phrase has its own Wikipedia page, like it is just one of those things. So racial discrimination and discrimination against people from the global south, these are key structural barriers that we need to get rid of. I must, of course, pay tribute to the interconnectedness of struggle and recognize that challenges faced by people with disabilities, trans women, indigenous people, and other persecuted groups, all of this needs to be addressed. And have to, of course, quote the amazing Kimberly Crenshaw, who says, if you don't have a lens that can be trained to look how various forms of discrimination come together, you are unlikely to develop a set of policies that will be as inclusive as they need to be. So as we sit here today, I want to encourage everybody to think about ways you can do better, ways your organization can do better. We need to remove these barriers, make space for true diversity, treasure it, and allow it to flourish so that we can be more effective human rights advocates and better people. Allowing discrimination and racial injustice to continue in the way we approach our work, in the way we engage with our partners, is really the reason for a lack of growth in our field. And that makes discussions like this so very important. And I'm so grateful to have been part of the organizing committee for this group, because most of the speakers today are women of color. And that's incredible. And it's not like that often. So I think I'm encouraged because there's hope and there's so much progress and there's so much potential and room to maneuver. And I hope that we can build on this and remain self-critical, remain open, but remain positive and optimistic, because as Angela just told you, we do have hope. And so my hope is that this is one of many conversations. I was at ASIL 2 weeks ago and was able to share a similar thing on a panel that was entitled Decolonization and Racism in Human Rights. So the discussions are happening, the space is growing. So let's talk, let's keep talking, but also let's simultaneously take action. Thank you.
Thank you. Thank you so much, Angela. You just got my brain ticking. I had prepared my own barriers, and I looked at institutional barriers. So she just got me thinking. I was just thinking some of the institutional barriers to victim participation are institutional. Look at the composition of the courts, the international courts and the national courts, composition of women and substantive women who could speak to these issues. And then she just got me thinking, how many women of color do we have in these international bodies? If we do the statistics at the ICJ, at the ICC. And surprisingly, when I was looking at my statistics, the African Court for Human Rights is actually the only court that has an almost fairly balanced women to men agenda. There are 6 to 11 judges at the African Court. So is this something maybe that the other courts could also look to? I mean, it could be an example from the global south to the global north. And then also it got me thinking, is justice losing out on something by not including women of color on the agenda? The last conversation, Sarah just spoke ably to the fact that we would have needed Ugandan voices in that case. Angela just spoke to the fact that there is so much that the victims still have to say that we don't know, that if we spoke to them in a familiar language, in their own identity, maybe we'd get something. So maybe is there something that justice is missing by this racism, by this lack of inclusion? So that will take me to Alexandra. You could speak to us. Thank you.
Thank you so much, everyone. I think now it's on, yeah? Okay. So thank you so much, everyone who is here and present today online, who traveled a long way, and thank you for your presence in this room. I'd like to thank all the speakers that are here in particular, as well as my fellow organizers, in particular, Lorraine, Angela, Jocelyn, Bruna, and the wider team, Akila, as well as Sydney and Emily for supporting and making this meeting possible. By means of introduction, my name is Lily, as mentioned, and I'm one of the 5 co-founders of the Emergent Justice Collective. And this is a newly found collective that really seeks to nurture some of the emergent counterculture to white dominant practices in the international justice space. And we seek to do so by really centering some of the intersectional approaches that were mentioned today to find out what community, what mutual transnational feminist solidarity means in practice, and how can we also bring in healing when we speak and practice accountability processes. My intervention today is based on my positionality as a white, genderqueer, able-bodied person from countries that have colonized and exploited others without reparation. And because it hasn't been mentioned, I do express my solidarity with those affected by the anti-homosexuality bill in Uganda that criminalizes the existence of queer and trans lives with life and death sentences, and also those who are carrying out, and some of them are here today, important gender justice work in Uganda, and they are now hindered and threatened in their work. So I urge all of you to voice your support by, for example, supporting the hashtag #WhatNext campaign that is queer and trans led and that has very concrete demands how to support those that are threatened. So from a point of professional ethics, it has become increasingly important to me to grow not only my technical capabilities and learnings as an international justice practitioner, but also at the same time to work on unlearning and learning, addressing, naming, and confronting the structural inequities and harm in the way international law, international criminal law is practiced. In this, I build on, I listen, and I learn from the thought leadership of Twale scholars, critical race scholars, and legal scholars with decolonial approaches. And just to name the few for those who are interested, these include Sarah Ahmed, Aftab Bra, Foluka Adebisi, Tendaye Achumi, Sylvia Tamale, Nikita Devan, and Maria Lungones. And my brief opening reflections will focus on, and we talked a lot in recent years and decades, and there was immense work done in the feminist spaces on the gender competent analysis and frameworks in doing international criminal justice work. And I want to pay tribute to this. By the same token, I think it's really the point now where there is a movement that demands more than just a gender lens due to its relationship to coloniality. And I think now we need to explore and ask ourselves, what is an intersectional decolonial feminist analysis of international criminal law? Its institutions, but also the way we practice it. Decolonial feminism, or alternatively feminist decoloniality, provides us really with an analysis of gender that at the same time also accounts for coloniality. And with coloniality, I refer to the structural continuity and impacts of colonialism into the present day. And it also does the work for moving us from quote unquote the slogan of gender equality to a deconstruction of colonial dominance that is exercised, has been exercised with present day impact through, among others, the control of the economy, the stealing and the hoarding, and the control over land, the control of authority, the control of sexuality, and the control of subjectivity and knowledge. Who is the expert and who do we see as such? As came out today in previous discussion and also by my dear fellow panelists, I'm on the one hand really hopeful and driven by the potential of change, and I can really feel and see it present today. At the same time, I feel alarmed, and I think these two tendencies can coexist. I'm alarmed by a polycrisis in the international justice field. And this polycrisis demands us to be polycritical of the way coloniality and related racialized and heteropatriarchal hierarchies manifest in one, the law in and of itself, and the way it is being applied. Two, international criminal law institutions and the related international justice architecture and some of the experience Angela and others share and continue to share because it matters and because it needs to change. And three, the way we work with one another in the international justice space. And one concrete example is really the divorce that we are seeing or have seen in the context of the feminist collective that intervened as amici in the Ongwen appeals chamber, and the very real work of those working in community on the grounds on the very same issues, but we are not connected. How can we be connected? And here I would like to uplift the critical work of Dr. Yassine Branger and her work on Black internationalism and international criminal justice. And she will give a talk on that very topic, answering some of those very questions on the 16th of May at Sydney Law School. Unfortunately, the event is not hybrid, but those in Sydney, please go and follow it. So I'm now using a decolonial feminist analysis as a framework to share some observations. So I start with the observation that among the international justice community of practice, with those I mean the people, the institutions, the organizations concerned with justice and accountability for international crimes, that community of justice operates, albeit very well-meaning and with a lot of determination, in a manner that's somewhat divorced from addressing in a structural transformative way, such as Sarah mentioned this morning, the injustices and harms. And I see those not being addressed in two ways, both the mass violence it seeks to redress, but also the harm that occurs in the context of the work that is being carried out. I also see through decolonial feminist analysis an uncritical overpromotion, if not overpromise, of criminal law as the sole and primary avenue towards justice and accountability. Ukraine was mentioned as an example. I think it's really problematic to just like see states basically being able to kind of outsource with a lot of money an issue that is on a very structural level and that we are disconnected from as human beings. I think what gets lost along the way is support and resources for avenues of justice that are non-criminal and that are non-judicial, and where the resources go to the people that are concerned with the violations, not intermediary actors that step up in their name. I also observe leadership at INGOs, at international criminal courts, to bear a particular resemblance and a leadership style to regimes whose harms international criminal laws offers to redress, essentially, without any accountability in these institutions, in these organizations, often without any confidential pathways or other means to do so. And I also want to acknowledge that we often come together to speak about the what we are doing. We are very comfortable with our technical expertise. Again, we are experts in our own name. We are comfortable to come together as experts in response to a posed problem or crisis. We are comfortable advising states, serving institutions, but these institutions are founded with and on the basis of colonial logics and colonial dominance that thereby we are serving. Seldom we come together, and maybe this meeting is an exception to this that we should cherish. We seldom come together to vocalize what are our mutual feminist commitments to one another in carrying out this work, and how do we work towards such commitments, and how can the work I do, we do, be of embodied and transformative impact to someone else. And that's not something I can come up with myself. This is something we need to work on together. And I asked myself, following these thoughts, how would the world look like if we had the means, the frameworks, the resources to engage in abolitionist imaginings together, and also transformative justice responses to mass violence alongside judicial avenues? And how can we come together to kind of co-create, co-imagine, and co-lead through mutual feminist commitments between all the experts that are in the room and are experts in their own way? Two things that I like to flag as particularly dangerous, I think, is also the way that we do not talk about or practice international law or international criminal law in a way that it truly accounts for the coloniality involved in the mass violence we are seeing. Again, it goes to the structural continuity of the crimes we are seeing. So, for example, we do not examine in the framework of international criminal law, because it follows colonial logic, the relationship between the colonial crimes and harms that violently ripped apart people from their land and land from its people. And we don't connect it or draw the relationship to those harms, to the mass violence and armed conflicts we are seeing nowadays, and which international criminal law aims to account for example, such in the Ongwen case. And without claiming to have any solutions, I believe as a first step, we need to push more, to crave out more, and to carve out more opportunities to learn, unlearn, and make speakable what is not spoken about at this very moment. I think we heard the statistics from Angela, and we need to take them seriously and really take them to heart and explore what it means for the people we are. The philosopher Sarah Ahmed asks, if whiteness gains currency by being unnoticed, then what does it mean to notice whiteness? And Ahmed, for example, invites us to look at the whiteness of institutions. For example, we could take the International Criminal Court to see institutions as an orientation device and as an orientation to show us what is within them. Again, this is not a binary approach, but it's an analytical framework that we need to start to use. What I'm really excited about, however, and I'm going to close here on a positive note, is how can we learn from initiatives such as the Feminist Collective that formed around the Ongwen case and the Amici? How do we really take on board and come closer together? How do we expand this architecture to ensure we intentionally and we effectively, and I think it's really a question of design process, and through creating intentionally these processes, we can respond to the structure and equity of the system we are working in. In that case, it was the International Criminal Court. It was a call by the appeals chamber, but these structure and equities will face us wherever we go. So it's up to us for the moment to come up with processes that are mutually designed and realizable for all of us together. So I'll leave it here and I look forward to additional.
Thank you so much, Lily. I think Lily has really put together the interconnectedness of different justice mechanisms depending on how we decide to put them forward, how transformative the law can actually be in so many ways. And she has actually also highlighted the limitations of international criminal law, that as we know them, in terms of how much they are so political and the fact that it stems so much in institutions and all that. And I was really so intrigued at the fact that she looks at transformative ways in applying other alternative justice processes. And I was just thinking with this whole idea about so much violence and negativity about LGBTQ rights, how much can the other alternative justice systems also support that process? Because right now we look at it more in terms of the formal, and yet also there is a lot of contrast with the of course, I'm from Uganda, and some of the defenses about some of these issues is that it's a colonial issue. So I mean, like also bringing it forward to communities who believe that some of these issues are colonial to. So I mean, it's so fluid, but it's also so challenging in a way that I think it takes experts like Lily to be able to bring it for us to the table and to be able to understand that. And I think it's really a very, very commendable a piece of work that you're doing. Thank you so much. So I think I'll go back to our speakers again and pose a few questions before we get to the group that is on Zoom right now. So I'll start again. I'll start with Lily. You're right next to me. So I'll just ask, what does transnational feminist solidarity mean to you today?
Yeah, I think I already touched upon this, that I mean, I ask myself this question basically every day, but then the follow-up question is, what do we do about it in practice? And I think understanding transnational feminist solidarity through a decolonial feminist lens means that I am committed to a mutual commitment to another person, to another community, and I don't look for sameness, right? So how can we really care about issues that do not concern us? And how do we not override these issues but by what we think is best? I think it's also important in practicing this this kind of transnational feminist solidarity that you cannot look for sameness, and that you really need to come in with this internationalist and at the same time anti-imperialist lens to the work. So I think the question is, what are my international decolonial commitments in light of the fact that I'm historically and presently morally implicated in the atrocities all around us, and what am I going to do about it? What are we going to do about it? I think in this journey of answering the question for myself, a really critical piece was Sister Outsider by Audre Lorde, and I would just like to read a quote from that. You do not have to be me in order for us to fight alongside each other, and I do not have to be you to recognize that our wars are the same. What we must do is to commit ourselves to some future that can include each other, and to do the work toward that future with a particular strength of our individual identities. And in order for us to do this, we must allow each other our differences at the same time as we recognize our sameness. When we define ourselves and when I define myself, the place in which I am like you and the place in which I'm not like you, I'm not excluding you from the joining, but I'm broadening the joining. Maybe I'll leave
Then I think I'll move to Angela. How do we avoid tokenism in this place, for example, in this space?
I think there are several things. So first of all, tokenism is the minimal acceptance of people of color, like just having one of them there, right? So often people go for the trifecta. You get a woman, you make sure she's from the global south, you make sure she's Black or she's a woman of color. And then they're like, I've ticked the diversity box. Look at how diverse my panel is. Meanwhile, that woman is sitting with predominantly white men on her panel. So I think this is, and again, to quote Audre Lorde, because she's really good on this, she said that tokenism that is sometimes extended to us is not an invitation to join power. You're just there to tick the box. And we need to avoid it because you're not genuinely appreciating the expertise and this experience that people of color bring when you just need one there to tick your box. You're not doing what Angela explained earlier, that we're all individuals and we all have different things to offer. And so once you can genuinely understand and accept that, you will see that it's not just about having one person. It's about having as many people as you can, being fully inclusive and fully diverse. And I think we also need to stop perpetuating that narrative that there's only room for one person of color at the table. Make more tables, bring more chairs, like there's space, right? But for as long as we keep this false notion going, then you're creating scarcity that doesn't exist. I think that's something else that also needs to go. And we need to understand that representation and visibility matters. Like the younger generation of lawyers that will come after us need to see themselves represented in these powerful positions. And that's why it should be about more than just making sure you've got one token person of color or from the global south on your panel, in your team, in your organization. We need to think broader than that. And also I would think of it as, how can we foster a spirit of solidarity? So for example, if you find yourself as a white person invited to speak on a panel and there are only other white people on the panel, maybe you can say, my participation is contingent on you diversifying the panel, because you have that power and you have that sort of influence. So I think we need to think of ways we can act in solidarity. And there's small ways, there are bigger ways, but these are just a few of the thoughts that come to me as you ask that question. And I think lastly, I've heard people say, oh, well, we couldn't find any more people of color. And I say, well, how hard did you look? And where did you look? And how long did you look for? So I think just more effort, more energy, and a genuine commitment to making sure that there's adequate and equal representation is really important.
Yeah, that's really interesting. It's something similar that we have back home when we talk about women empowerment, and someone says it's just lip service. It's just, okay, let's have so many of them, but what's the substance that they bring to the table? So yeah, I think that's really key in terms of that. And I think also the fact that I think sometimes the word inclusion is used so much to validate projects. So I say it's inclusive. So I say it's this, but actually what does that mean? I think that's really important. I'll get to Lorraine. Could you share some tangible views and steps that you think could secure equitable, effective, and meaningful participation?
Thank you. I'm still reflecting on some of the thoughts shared by Lily and Angela and Angela, who is next to me as well. But there are several ways, and it depends on the context. It depends on where participation in what and where. So for example, at the ICC, tangible ways, of course, could be that some of the courts work in this area, and I'm shouting out to states. We need to recognize that, for example, outreach is a core activity. So ensuring that victims are informed about what is happening is a basic. We have a new registrar who has his roots in civil society. I'm expecting, of course, that there will be prioritization of outreach to victims, of engagement with victims. And that will, I think, help to ensure that you pull in broader numbers of victims who understand the proceedings and who can be a part of it. think the second thing, of course, is that ensuring that the lawyers who are representing victims, I cannot believe this is nearly 10 years now, but there's still a debate as to whether or not they are entitled to legal aid and how much, and there is a new legal aid policy, and this discussion continues. The reality is that these issues need to be resourced. And so one of the ways of ensuring more inclusivity is putting money where the discussions are, putting the money where it is needed to ensure that victims are able to access these spaces. But I think beyond the ICC, at the national level, giving understanding that since we're not only talking about formal justice processes, we're talking about transitional justice processes as well. How do we ensure that survivor communities are fully engaged, not just at the initial stage? When we bring everybody together, we tell them that there's a transitional justice process that is going on. But when we are getting now to the crucial stage, where like there is a transitional justice bill that is before Parliament, how do we ensure that survivor voices are able to influence that process? I mentioned earlier that in collaboration with Gweji, and they were actually the lead on this, we went to some of the women leaders in Northern Uganda and we asked, what are your thoughts about being part of decision-making processes? And they made it very clear they want to be involved. And just in case I doubted the validity of that, Angela just said it. She said, we want to be heard. What we found though in that survey is that part of the challenge comes from the perceptions about women activists, women-led organization, the perception that they cannot be trusted with certain resources. So it has to be done through larger organizations because they don't know how to do it. And so because they lack the funding, because they don't have the resources, very often these organizations are not able to advance. So they are relegated to certain roles. They can mobilize, bring people together. They facilitate meetings coming together. But in terms of actually getting their voices and being able to contribute to the process, we saw tremendous limitations, and they told us about that. And so my final call is to funders. It comes back to the money issue. How do we ensure in a realistic way that those who need to be part of decision-making spaces become a part of it? Well, firstly, we fund them. But I understand the challenges that funders have because we've also talked to funders. They have certain guidelines, they have certain requirements. So what we are seeing as gaps, tangible gaps with women-led activist organizations is that there are certain, the tools are lacking. So they understand what needs to be done, but because their focus is on downstream and midstream interventions, they are not concerned with the upstream. They want to get involved with upstream. And by downstream and midstream, I mean, for example, they're quickly going to respond to their constituency in terms of helping, building economic, doing economic activities and certain things. But when we begin to talk about things that take much longer, like engaging with Parliament, like engaging with policymakers, the resources are not there. And so this is where I think funders may need to redirect some of their activity in helping to build the capacity of women who lead these organizations so that they have not just the resources, but they have the tools to engage in the long term. And we've seen that. I'm very happy to share with those who are interested. Our report is much too long. It's called Empowering Women Leaders to Soar, to strategize, organize, and what was the other one, Pamela? Strategize, organize, arrange, and to, it's in front of me, but they just left me. But I tell you that this is one of our, in fact, I have it, it's right in front of me, to strategize, organize, advocate, and to rise. Because at the end of the day, what we've discovered is we can talk as long as we want about the ICC and structural and institutional barriers. If we do not equip women leaders at community level, we are not going to get very far. And their priority right now is reparations. But they are doing work. This is what Angela is. This is 10 years of operation. She is working. So how do we help her and other similar organizations to scale the work that they're doing? And by helping them, we will ensure that there is increased participation in transitional justice processes and international processes like what is happening at the ICC. Thank you very much.
I think I'll go to Angela Lacour. So what do you think would be the steps, the tangible steps that could also be taken to ensure proper victim participation? Just taking off from Lorraine.
Thank you so much. Once again, I think one of the steps that we should take is trying to reflect on self. Why am I doing this? Why am I working for the victims? Because one of the things that I see, I'm going to answer that, but one of the things that people don't realize is that there are organizations that work with the victims that are also stressed. So, and they also go through a lot to work with victims. So one of the steps is to understand that, am I the right person inside you to do this? Or I'm doing it just because I don't have any other job to do. And then later we go to see that the bottom-up approach of still going back to the victims. If you understand that and you have the interest in, because this is too much of working with victims, not only in Uganda, it is too much work. It is too much stress. It is too much sacrifice. And it is too much of mental, you're exhausted, every time, even if you're not affected, but when you hear the story, you're affected. So do you want to involve yourself in? So if you want to involve yourself in, please reach to the victims and understand them. Go down there to the field. Avail yourself to communicate with them in order to get the solution to their problems. And then we always say work with the victims. Of course, every institution or organization have the way or their principles or how they do their things. There are also other people that really work with the victims organization so closely. If you cannot go so closely to the direct victims, there are institutions that are working closely with the victims. And reach them so that you get the tangible questions or results that you need to address the future problems. Because right now, yes, we are crying things, of course, for a solution for something to come out, there's going to be a longer period and there's going to be a lot of challenges. So we learn through it. I think that is what I can say.
Maybe Angela, I'll just again take you back and then go back again to Lorraine. With what you've said in terms of what it means to include victims in this whole process, what again do you think it would mean if victims were not included in these processes? Angela, what would it mean? Yeah, like lack of inclusion of victims in the processes. To you, what would it mean in terms of how legitimate would such a process be? Just
I think one of the things, if there's lack of inclusion, then there's no information. What are you doing? There's no results. There's no ownership, because let the victim own their stories. Let the victim own be the reason. Let them work together with you to resolve their problems. I think that is all I can say about that.
Yeah, and then maybe again back to you, Lorraine. I was just wondering why you think probably it's important for the victims' voices to be included both in the national and international processes, just like you had earlier on alluded to that in terms of. Yeah.
No, absolutely. I think if we're going to have meaningful processes and we don't have victims' voices, then everything rings really hollow. I mean, we need to have victims because well, firstly, from a contextual perspective, there is just simply no way to really fully understand a context that the process is happening in if you don't hear from those who are most impacted by it. And what is interesting, and I think we've seen it even in this session, we've heard from Angela, we've heard so far from Victoria, but they have very different stories. And every time you hear from different victims, you hear their experience might seem to be generic, but it never is. I was having a conversation in the margins of the meeting with one of our participants, and he said to me that, how do we ensure as lawyers that when we are listening to victims, when victims speak, that we even understand the way they speak, that we ensure that we hear them and we understand their way of speaking. And that requires us to take the time. So it is meaningful, Margaret. In fact, I can tell you there's an organization which I would encourage everybody to look at their website. They're called Innovas. It's a global network of victims. It was facilitated by Impunity Watch. They've started, and it's a network of victims from around the world that was established because members felt that any of these processes needed to be rooted in local context. They wanted to move away from top-down, quote unquote, expert-led transitional justice processes and have survivor voices from the bottom up. And you know what a Sudanese victim said in a meeting that we went to at the ASB? She said, am I not an expert? She said, with my lived experience, I am the expert. So while I value everything that other experts bring to the table, what about my expertise? So she couldn't have, so that's why victims need to be part of the discussion. Thank you.
Thank you. I'll quickly go to you, Angela. You've talked about this whole exclusion of victims and survivors and how it affects your work. What could you say more broadly in terms of providing opportunities for people from the global South in terms of making it more legitimate for international criminal law and human rights?
I like that you use that word because I think it really is a question of legitimacy. Like if we're not diverse and inclusive, the legitimacy of these institutions and the work they're doing is at stake. I think it was 3 years ago that the UN, it was in Reuters, it was published in Reuters, and there was a survey that was sent around internally to the UN. And it was about, the campaign to eradicate racism and promote dignity. And the first question for staff members was, how do you identify? And one of the options was a historically Western and racist way of referring to Asians, which was yellow. That was one of the boxes on this UN survey. And it was, it all came out in Reuters. And when you think of an institution like the United Nations sending around a survey like that internally, we have to ask ourselves some important questions. And we have to think about this from a legitimacy perspective. Switching to the ICC, we've all heard that ICC Africa tension and the ICC is targeting Africa. Now, like whether you believe that or not is not the issue. I think personally it's far more nuanced than that. But the point is, it's a widely held perception. And having top leadership at the ICC, which is 55.6% white at the moment at the D1 level, doesn't help that perception. So we need to think about this issue in terms of a legitimacy question for these institutions and the work that they are trying to do. Staying with the ICC, also thinking about how cases are investigated, how prosecutions are conducted, and how judgments are rendered. If you send in a homogenous team that's not diverse to investigate, let's say, sexual and gender-based violence in a remote area, that's not asking the right questions, that's not sensitive to the cultural dynamics. What kind of evidence are you going to get? What kind of harm are you actually bringing to the victims and survivors? Because you're not reflecting what's happened to them in an accurate way because you don't fully understand it. So I think this is really a question of legitimacy, like diversity, inclusion, and genuine representation is a question of legitimacy for all these institutions.
Thank you, Angela. Lily, maybe you could speak more about some of the root causes of the structural barriers and the dynamics.
I will, but first I want to say something else, which is what is coming up for me, which is really, I think I spoke about transnational solidarity, but I also want to reach out the call for transgenerational, transnational solidarity. And I want to share an example that's very close to some of the discussions that we are having, which is that not only was the feminist collective involved in submitting the amici, and some also went to The Hague to present and also online, but we also put together an online symposium at Opinio Juris to make some of the legal points we raised more accessible. Part of the symposium was an opening piece by Angela and myself, and we felt it's important to write this opening piece from a point of feminist self-accountability and also growth, because we know we want to gather in a feminist collective way, but we realized already, and that was, I think, in May 2022, that there are some things that in terms of process and design and infrastructure of how we work together, there's room for improvement. And we wanted to write a piece that really centered some of these structural shortcomings that are representative of power dynamics in the space. So what we mentioned was, among others, the lack of representation from Ugandan survivors, from Ugandan experts among the collective, and that was a symptom of systems of colonial logics that is also present within ourselves, and that we have to reimagine the way we work more equitably with one another. And as a courtesy and as something we wanted to do, we circulated the initial draft and received responses from people we felt safe with, from people we thought were our allies in this feminist collective. And we were essentially told that we should not publish a piece at all because it would undermine the amazing efforts of legal experts. We were also told that we shouldn't publish the piece first but last at the end to not undermine the perception of the other pieces. And I'm mentioning this because I really believe that we can do better than this collectively, that we don't need to fight each other in this space, that I also recognize that maybe some of us had to adopt patriarchal leadership styles to get where we are, and we stand on this very work and on these very efforts at the moment. But I think from a point of love and care for the work we do, this is not how we can work together in the future. We cannot fight each other in the little energy that we have left. We have to focus it somewhere else. And I really call in here, especially my white colleagues among us, we can and we must do better in that regard. So I think without answering your question, that's the story I wanted to share. And it is as much part of, you know, the amazing work that went forward, and a huge learning curve for all of us as well.
And we published anyway.
So I'll open up questions to the plenary. If any of you have any questions to the panel, we have a few minutes. So I'll allocate, I think, about 5 questions to the plenary, then we go to the colleagues on Zoom, and then we wrap up.
Hi, my name is Ramya Jawahar Kureklu. I work with Jocelyn here at Cardozo. So I just had a comment and then a question. Thank you so much, first of all, for this fantastic panel. Each of your reflections were meaningful. I think my mind is almost spinning. to how I can think of responding. But one of the things that I wanted to begin with, and something that I'm weary of, and I think it's a common thread that has come out of all your comments, is that I'm wary of the way that we are not often able to reconcile two things. One is that we're not often able to reconcile the importance of centering survivor activist voices and narratives without creating an understanding that the proxy for funding means ownership. And I'm really concerned that when we, particularly Global South voices, particularly voices from community-led organizations, are demanding funding, we're almost conceding to ownership of that narrative. And I think that when we think of donors or when we think of contributors in terms of resources, there's always a tension about how we imagine ownership, or how we continue to envision ownership of narratives, ownership of knowledge, and institutionalization of knowledge coming from survivor activists. And I was wondering if anybody from the panel can talk about what that tension is like with donors, but most particularly, and as a matter of responsibility for this geography, what that tension is like with scholars who come into this space, write scholarship, use these narratives, and can be quite extractive because victims may not be co-authors, victims may not even make it to footnotes, and may not even be acknowledged in some of these texts that are being published. So I'll push you to really not just challenge us, but hold us accountable in this space for that. The second thing that I wanted to just reflect on is the concern or the wariness we must have about when we think about decolonial processes and decolonial lens, to understand that post-colonial realities are colonial. We are operating within laws and systems and penal codes that are the remnants of colonial power in post-colonial realities. And we have been, because of the history of colonization, we've been robbed sometimes of the imagination and the oral understanding of what paradigms of justice existed before colonial powers came to these places. So even when we think of resources and investing in decolonial processes in post-colonial contexts, we have to make space and give grace that we're women and we're non-binary individuals who are still operating within very much colonial structures, and expanding imagination not just takes resources, but takes time and space and pontification that women and non-binary folk don't have or cannot afford. And so the demand is important, the collective consultation is important, the resource is critical, and that resource must be unabashed. It must be without strict, rigid, and unfair guidelines and requirements and monitoring and evaluation dictates. And it needs to acknowledge the reality that freedom of time and resources is required for critical thinking and imagination, as much as it was in abundance in the global north. It is that same abundance we seek in the global south.
I'll take all the questions and then the panel will respond.
Just a quick question that is maybe building off of that point and looking for practical guidance. I've been thinking a lot in the last week, obviously, about the possible Crimes Against Humanity treaty and what our strategies should be in engaging with that process. And so I'm wondering if you can provide thoughts on how to engage in state-led justice processes, states that are, post-colonial and yet, of course, still very much colonial products, how to best engage with that reality and work through a state or underneath the state level or against the state infrastructures to actually engage with the victims and the citizens of states, where states are sort of the driving entities in these processes.
Okay, thank you so much, Margaret, and all your beautiful presenters. I wanted to give one more remarks and probably tease out the challenges that grassroots groups, especially women-led institutions, and also victim and survivors, and where the problem is. So one of the problem, apart from top-bottom approaches, is actually too much validation of understanding what is happening at the grassroots. And this also goes to researchers. Sometimes the scope of research is not questioned and people make a lot of assumption. And already even funding and donors begin to make decisions on what they want to see and the kind of result they want to see before even engaging with the local person, not believing in local solution to address some of the local problem. And you find that sometimes the strategies are very high level and does not fit within the methodology and approaches at the grassroots. And that makes the grassroots leaders more disconnected from the implementation and decision-making and platforms. At the end of it all, you find that resources are wasted. So I think we need to have intentional decisions of inclusive approach for the people at the grassroots, especially also when it comes to consultation. The issues around inclusiveness and mainstreaming is a long conversation, but sometimes practically they are not really like that. They are not implemented. And sometimes the issues around resources comes too much discussion about accountability. And if you look at the structures that the grassroots women needs in terms of institutional capacity building and supporting them to technically become sound, is something easy to do because you might need to set up a system that works and probably put them to work in partnership. But nobody is interested of engaging the leaders at the grassroots to see how they can better understand how to implement. Then we make decisions for them. And then we come up with something that cannot be achieved, you know. So lack of trust, relationship building, and understanding the context at the grassroots is critical, and that is also what is missing. Victim voices and victim-centeredness is the usual conversation we have, but we need to understand the scope of the war and also the impact of the war and the intersectionality related to the impact of the war. And that's why Lorraine still mentioned the fact that you can speak to 10 victims and you hear different issues around that. And that means that 20 years of war might take 20 years of rehabilitation, reconstruction, recovery, and return processes. So how are we deepening our process is one of the things. And probably if somebody has some ideas on how we can deepen this to allow us surface with the best strategy and also avoid judgment, avoid thinking that you already know you want to speak for them. You already know the answer even before you ask them this question, and you are linking your answers to probably some years of research that has been happening, and yet they are transitioning all the processes. So thank you.
Two more. Okay, one here and
oh, sorry.
Thank you very much. I really enjoyed this panel. Thank you all for your reflections, particularly on how to reconstruct systems of power that shape international criminal justice. And I think this conversation itself is an important starting point. The starting point should always be to acknowledge that this is an issue, that this is a gap, that this has to change. And then as Pamela was saying, be intentional about it. Which knowledge systems are centered and which ones are marginalized. You know, we talk about gender, but we know meaning attached to gender is very, very context specific and based on history. So when we talk about gender-based violations or section gender-based crimes, whose lens, whose interpretation are we applying? So that is also one aspect. But we've talked about structural barriers, and in addition to the great work that the Feminist Collective did, I want to share another clear example which dismantled this. As you know that after the conviction of Ongwen, there was a call for submission of amicus on reparations. The usual practice has always been Western organizations agree on the themes, and Angela there will agree on specific topics, issues they'd like to address, and then invite groups or organizations in the South to sign on. It's okay. And others asked with specific timeframes, okay, what's your view on issue X, Y, Z? No one is asked whether you're going to contribute, whether that's an issue you want to address, but what's your view on issue X, Y, Z? And as I'm uniquely positioned as a Ugandan human rights activist, but working for an international organization with some level of expertise. When these issues were sent to local organizations, I was asked, they sent me an email, Sarah, I've been asked to fill this. What exactly does it mean, you know? So that was the premise. I wrote to VPRS and told them, look, Ugandans have been working on issues of justice for victims for so long. Local organizations have accumulated knowledge on what harms, what it takes to repair what needs to be done. All they need is a process to understand how can their views be taken into consideration at the ICC. At first, there was a bit of reluctance, but finally VPRS agreed to organize an information session. And at ICTJ, we said, we're going to mobilize. You just provide us with your experts who will tell us about the procedure. How do we apply to be amicus? We'll get everyone who needs to be part of it. And we invited, and it was a virtual meeting. It didn't take much, a virtual meeting. I just went through an nitty-gritty. If you want to apply, you need to submit 5 pages, you highlight your issues. And they did that. And they submitted to a court, and the court granted a number of them leave to apply as amicus, and they were admitted and they submitted. Never mind whether their issue, what they submitted was legal, but it was based on their perspective of what are the harms that arose from these crimes, and also the questions that the court had sought amicus on, prioritization, identification, all those things, and they submit, and I believe it enriched the process. But to me, that's a clear example that if you take time, do away with the assumptions that everybody has access to by the ICC page is very difficult to navigate. To go to ICC page, even get the information that you're invited to submit amicus, you know? You don't, I mean, like this one on the appeal, I got to know it a day before the deadline because the person in the Kampala office asked, are you guys going to submit? I'm like, I didn't even see it. I don't know about it. But all I'm saying is this, who has access to this information? It's no rocket science. Some of it is so basic, but taking those simple steps can really go a long way in bridging this gap.
One more question at the back. I think there is some more questions. There are questions, I think, also online.
Oh, great. Thanks. I'll make this very brief. So I asked Victoria earlier this morning whether she felt that reparations or justice was more important as a survivor. And she, of course, didn't answer me, which is fine because we're good buddies. But the reason I asked the question was that I think there's a different perception about reparations in particular between survivors and lawyers. I mean, if you talk to survivors, a lot of it is about poverty and money. And, you know, we've done a lot of work with relatives of the disappeared in Nepal, and there is a gulf between these people and the human rights organizations, the NGOs in Nepal. To the NGOs, it's about law and laws, universal standards, but to the survivors, it's about money. And I think that this surely applies in Uganda. I mean, Victoria's group, Angela's groups. I mean, these women are single mothers. You know, they came out of the jungle. Many of them were rejected in their villages. They got hammered by COVID, much worse than others did. Their need for money is enormous. And I think, I just don't know whether the human rights lawyers and the lawyers on the one hand and the survivors on the other, how do you have a discussion about that? Now, human rights law loves reparations. I mean, it's a growth industry in human rights law, but I don't think that really it's about rights. I think it's about needs. And I think we have to find a way to talk to survivors so they tell us what their needs are. And we need to listen. And it may be that there are other instruments and other vehicles for addressing that need. Now, I mean, I don't want to talk for Angela or Victoria, they can speak for themselves, but I just wanted to give you my perception. Thanks.
Thank you. I think I'll go straight to the panel. If there are any gaps, then I will answer as moderator. And yeah, because we are really out of time now. So any of you can take on any of the questions that have been asked.
Okay, I'll just very quickly take on the question about crimes against humanity. I think with any of these processes, particularly in international criminal law and lawmaking and states, I think we need to be very cognizant of the neo-colonial dynamics in these settings. And we need to understand states that are reluctant or states that are for why and what's that about and how do we unpack that. And in your engagement with states who are reluctant, for example, I think approaching them with a sense of humility and not with a sort of know-it-all attitude, and also tailoring your advocacy in a way that addresses their core needs, which means you have to understand what their core needs are. And if you don't understand the neo-colonialist dynamics that come with international criminal law, then I think addressing their needs, you're not going to succeed. So I think it's really a case of understanding the dynamics and being frank with what you know and what you don't know, but also approaching them with that humility and allowing them to really feed into help you tailor your advocacy in a way that makes sense. And I think also then working collectively with civil society is very important, civil society in these respective countries, because they understand the dynamics in a way that you wouldn't understand, right, if you're not part of that context. So I think it's all about the humility in your approach and thinking of it from their perspective, but also understanding that you will not know unless you ask them in the right way, unless you come at them in the right way. And I think often international organizations or Western-based organizations come with a completely wrong attitude to African states in particular. I think there's a real condescension in the way that they're approached and the way that they're engaged. And I think that needs to change.
Anyone else with an answer?
Let me jump in on, there have been so many interesting comments, and I know we can't unpack all of them, but I just want to pick up on this issue of ownership and what you mentioned about, you know, firstly, the issue of extraction, and you talk about, and we know that. We know, for example, that a number of donors, they have particular priorities, they have specific mandates, and so when you then engage with community-based organizations, the question arises as to, as you said, a question of ownership. Whose material is it, for example, when you do certain types of research? And I think one of the ways that we've tried to work around that issue, or at least to deal with that, is to ensure that there is not just acknowledgement, but there is more of, we take a partnership approach to it. So for example, if we're producing a report, or the persons who are fully part of that process are acknowledged in the report as authors of the report as well, because I think it's very important also for the local voices to, you know, to be part of these processes, but to also acknowledge the significant work that they do. But it also depends very much on the funders. So again, when we're talking about making changes, we have to ensure that some of these changes come from, you know, some of these changes and these suggestions are directed to those who are the donors, those who are in certain positions where they are influencing the way we approach some of these issues. So I'll leave it at that, maybe because of time, but I think it's a really interesting point, and there's much more that we can pull from what you've said about this extractive approach. I did want to pick up on something that Sarah said, and that is, I'm going to call it the simple fix. very often, I think, as you've rightly said, we overcomplicate things. Sometimes there are very simple ways to ensure engagement. So as you said, you took the initiative to contact VPRS. But Sarah, part of that is because, as you said, of how you are uniquely placed. And that's a challenge that we've seen, not just with our Ugandan partners, but in several other contexts. How do we ensure that it's not just certain persons who are uniquely placed who are able to make these connections and to move in that way? And this is why this is an important discussion, to ensure that some of the other actors are known. And the ICC also, I think, has a responsibility to ensure that those who are working at grassroots are also known, and that they engage with them directly and don't feel that with a number of things they always have to go through some international actors. But some of the things are in fact simple fix. And I agree with you that we can, and I like the assertiveness that you demonstrated. You said to the VPRS, thank you very much for your list, but we would like to say what we would like to see. And I think that is something that is an important lesson for all of us, actually. The rights versus needs issue is the perennial debate, I think, of many of us in international human rights law. It is true. There are needs when we're dealing with human rights violations, and there will be needs always. But could we, as human rights lawyers, really say that we focus exclusively on the issue of needs without considering and advancing the discussion about and the importance of rights? How we balance that and how we actually ensure that there is a balance in that discussion, it's a perennial issue even for us. I see it on the ground. We have to advocate for for these rights in these contexts, but we cannot ignore the needs, and I understand. So I don't have any answer to it. I leave it there, but what I can say is that for the survivors that we've spoken to, most of them are interested in both. They want their rights recognized, while at the same time, they want their needs to be fulfilled. Don't know if we have to choose one over the other, but thank you.
Thank you so much. Painstakingly, I'll have to close this panel. But I think it's been really clear from the panel and from the plenary that there are terms that have been re-echoing: perspective. It could be good, it could be bad, ownership, transformation. I'll take back Ubuntu, because Lily, you mentioned something about us working together. If it's you, it's me. I mean, it's a South African word for oneness. So I think in this forum, if we can feel that you are me and I can be you, I think then we can make a big change in this world. So thank you so much for being with us. Thank you so much.
Thank you so much to everyone, every speaker on this panel. It was an amazing way to end our first day. We have a coffee break at the end. And then for those of the speakers, we invite you to have a debrief as well as to prepare for tomorrow. And I want to invite all of the participants who are excited for this event to come back tomorrow, because we have an all-star lineup tomorrow as well. We'll start with an opening conversation and survivor reflections from day one. And then we'll talk with Ambassador Beth Van Schaak, who will give us an idea about reparations for sexual and gender-based violent crimes and related issues from the perspective of her office in the U.S. State Department. And then we'll talk more about reparations in Ongwen and the broader impact on the transitional justice processes in Uganda. As you can see, this is the #1 issue, at least at the national level, for victim survivor groups. And so we want to make sure that we're having these conversations now so that we can continue to have them long into the future. And then, we will also be feeding you and sustaining you while you're here tomorrow. So please join us and give us, everyone here, another round of applause, and all of you for all of your participation today. So great. I have to say, this is the first time we've been back in person at the Institute for a conference of this magnitude. We're ironing out the wrinkles again because we forgot how to do this stuff. But thank you all so much for your patience and your generosity of spirit and being here in community, and your participation couldn't happen without you. So thank you.